Hello everyone, and welcome to the third of our video tutorials on non-fatal offences against the person. In today's video, we're going to be looking at malicious wounding or inflicting GBH under section 20 of OAPA, and also wounding or causing GBH with intent under section 18 of OAPA. Let's start by just reminding ourselves of the different non-fatal offences against the person which you need to be aware of. Assault and battery we looked at in video 1. They have a maximum sentence of 6 months. ABH we looked at in our second video, and that carries a maximum sentence of 5 years. But today we're going to be looking at section 20, which also carries a maximum sentence of 5 years, and the most serious of our non-fatal offences, section 18, which carries a maximum life sentence. We're going to look at both of these offences together today because the main difference between the offences under a section 20 and under a section 18 relate to the mens rea. The actus reus of both offences is the same. We're going to start by looking at malicious wounding or inflicting GBH under section 20 of OAPA 1861. If you were to turn to section 20 of that act, this is the definition that you would see. And because it's an act from the 1800s, the language is very antiquated, very old-fashioned. So it says, whosoever shall unlawfully and maliciously wound or inflict any grievous bodily harm upon any other person, either with or without a weapon or instrument, shall be guilty of an offence and shall be liable to imprisonment for not more than 5 years. Now, you might have noticed that the maximum sentence of 5 years is a bit strange because the maximum sentence for ABH section 47 is also 5 years, and section 20 is more serious than ABH. So why is it they've both got the same maximum sentences? Well, nobody knows. We think it was a mistake in the Act of Parliament, but because it was written in 1861 and everyone who wrote it is dead, we can't ask them. But to be honest, it doesn't matter massively because if it's ABH, you're going to get the lower side of 5 years, and if it's GBH section 20, you're going to get the higher side of it. So now that we know what our definition is, we need to pull out what is the actus reus and what is the mens rea of a section 20. So to begin with, hopefully these words jumped out at you. Wound or inflicting grievous bodily harm. And that's basically what your actus reus is. So the actus reus of section 20, you've got to show that there was a wound or GBH. So importantly, you only need a wound or grievous bodily harm to meet the actus reus. You don't need to have both. Sometimes you will have both and that's fine, but we just need one or the other. So we're going to start off by looking at what a wound is, and then we'll move on to looking at what GBH is. A wound was defined in the case of JCC and Eisenhower as a cut or a break in the continuity of the whole skin. That's a slightly strange way of phrasing it. Continuity meaning continuousness. So the judge here is saying that if you imagine your skin is continuous around your body, a wound is when you've got a break in that continuousness. And the way to know whether you've got a wound is whether you've got blood that you can touch, okay? So the court also pointed out in this case that if you have a look at this eye, I know it's a bit grim to look at, this eye is bloodshot. There is blood under the eye, under the surface of the lens. Now, you can't touch that blood because it's inside the body. So that would not be a wound. That is internal bleeding, really, isn't it? So for it to be a wound, you've got to be able to touch the blood. So if there'd been a cut on this eyeball and the blood was pouring out, that would be a wound. It might be that someone is punched in the face and they bite the inside of their cheek and then there's blood in their mouth. They could put their finger into the mouth and touch the blood, so therefore that would be a wound. If someone's kicked in the stomach and they rupture their spleen and they've got internal bleeding, the bleeding is internal, so it is not a wound. That would be classed as GBH because it is serious harm, but it's not a wound. And it's important for us lawyers to know the technical difference between a wound and grievous bodily harm. So a wound, you're looking for blood that you can touch. In the case of Wood, they were talking about a compound fracture. Now, a compound fracture is like this, where you've got a broken bone that has actually come out of the skin, and they're pretty horrendous to see. And this case said that if a broken bone is sticking out of the skin, it's going to be a wound because obviously you're going to have blood coming out as well. If you have got just a broken bone and it is not sticking out, this won't be a wound, but it would be classed as GBH. So this is quite an important case because Wood is telling us that a broken bone is GBH, but if it sticks out the skin, it's a wound. We know what a wound is, we need to have a look at what GBH is. So GBH stands for grievous bodily harm. The way that you could remember it, but don't ever write it in an exam, please, is great big hurt. Okay, ABH is a bit hurt, small injuries, whereas grievous bodily harm is big injuries. But obviously we need a definition here from a case. So GBH, defined in the case of DPP and Smith as really serious harm. And you might be thinking to yourself, brilliant, that's a really vague definition. And it is vague. But the reason the courts want to give a vague definition, GBH is really serious harm, is that with it being vague, it is flexible. It can cover a whole range of different injuries. In the case of Brown and Stratton, we added to this definition and said that a combination of lots of injuries, like poor Brian's got here, such as bruising, broken nose, missing teeth, concussion. If you've got lots of little injuries, that can be GBH. In another case called Bolam, they also told us something that hopefully is fairly common sense, that you also need to take into account the age of your victim when you're deciding whether something's GBH or not. Hopefully that makes sense, because if I punch one of you, a teenager, it probably won't cause much harm. However, if I punch a 1-year-old in the face, that probably would be GBH because it's going to be really serious to a 1-year-old. Equally, if I punch a 90-year-old in the face, that might well be GBH because to that particular victim, it's going to be really serious harm. So GBH, we know, means really serious harm. You must take into account the age of your victim when deciding whether it's going to be GBH or not. And you can also take into account the fact that there might be lots of smaller injuries which taken together can be classed as GBH. Now we've got some really interesting cases on GBH to have a look at here. And I think they illustrate the problem with having a law written in 1861. Because at that time, the way people injured each other was quite straightforward. Punching them, stabbing them. Whereas over the years, people have developed new ways of hurting people. So Deaker and Rowe, particularly unpleasant cases, where these individuals were deliberately trying to transmit HIV to other people, which obviously in the 1800s would be unthinkable. So the judges have had to extend the meaning of GBH to cover these new situations as they've arisen. This was Mr. Deaker. He was trying to inflict HIV on a number of women, and he unfortunately managed to do so. The more recent case, Rowe from 2018, this was a gay guy who was trying to inflict HIV on as many men as possible. Now, Deaker was a Section 20 and Rowe was a Section 18, and that'll make more sense when we've actually looked at Section 18. But what this guy was doing, Darryl Rowe, was particularly disturbing because he was having unprotected sex with men, and then afterwards he would text them and tell them that he thought he'd given them HIV and say things like, "I've got HIV, lol, I'm riddled." Hideous, hideous actions there. But that was helpful to the court because that proved without a doubt that he intended to give HIV to these people, so that proved his mens rea. But giving HIV can be GBH. Another really interesting case was Golding, and that said that inflicting herpes on someone can also amount to GBH. Look at the mens rea of Section 20 then. To be guilty of a Section 20, your defendant needs to intend or be reckless as to whether some harm was done. So it's not necessary to show that the defendant intended or foresaw GBH. Okay, you've only got to prove they intended or were reckless as to some harm. So there's our little summary of what I've just talked you through. Actus reus of a Section 20 is a wound or GBH, and we've looked at what a wound means, and we've looked at GBH with the cases. And the mens rea is intentional recklessness as to whether some harm was caused. We're going to move on now and look at the next type of GBH, the step up, the Section 18, which there is a huge jump from 5 years for a 20 to life for a Section 18. Wounding or causing GBH with intent under Section 18, if you were to turn to that section, this is exactly what you would read. Whosoever shall unlawfully and maliciously by any means whatsoever wound or cause any grievous bodily harm to any person with intent to do some harm to any person, or with intent to resist or prevent the lawful apprehension or detainer of any person, shall be guilty of an offence. I've stressed the word intent there because the key difference between a Section 20 and a Section 18 is the mens rea. So the mens rea for a 20, you intend or you are reckless as to some harm. But Section 18 is more serious and requires specific intent. But we're going to break this definition down and look at our actus reus and our mens rea. The actus reus of Section 18 is the same as for Section 20. So you need to prove a wound or GBH. And that means all of your cases are the same here. So you would use JCC and Eisenhower for a wound, you would use Wood for your broken bones, you would use DPP and Smith, means really serious harm, Deaker, Rowe, Golding, all exactly the same cases on your actus reus. The key difference then between a Section 20 and a Section 18, as I've said, is the mens rea, so we need to have a look at that. So a Section 18 is a specific intent offence, and that means we have to prove that the defendant intended. Recklessness is not enough here. They intended to do some GBH. And the other weird thing about Section 18, or they maliciously resisted arrest. In the case of Belfon, the defendant was slashing the victim with a razor, causing severe wounds to his face and chest. So we've got a wound, we meet the actus reus. Do we have the mens rea for a Section 18? And the court said yes, because for a Section 18, it must be clear that the defendant set out to do some serious harm. And if you are slashing someone in the face with a razor, clearly you intend really serious harm. Recklessness is not enough for a Section 18. The CPS have what are called charging standards, where they give some guidance as to the sorts of things that indicate that it's more likely to be a Section 18 rather than a Section 20. So for a Section 18, things that indicate that they've got specific intent are that it's a repeated or a planned attack. They're screaming, "I'm going to kill you," as they're doing it, that sort of thing. They've selected a weapon, or maybe they've broken a glass first. Glassing someone is a classic example of a Section 18. Maybe they've made prior threats. And another thing that indicates a Section 18 is using a weapon or kicking the victim's head. Because if you're kicking the head, clearly you're intending serious harm. The other way to commit a Section 18 is that they didn't intend really serious harm, but they wounded or caused GBH on a police officer whilst resisting arrest. And that means if they'd done this on a normal person, it will be a Section 20, but because it's a police officer, it automatically becomes a Section 18. To summarise, AR is the same as Section 20 with the same cases. MR is specific intent or maliciously resisting arrest.